of attorney here. Hopefully, you can all see that as well. Um, and so, going through this document, this is a statutory form. It is for your financial matters, where the healthcare directive is for obviously your healthcare matters. This is for your finances. And so we're going to go through this. It's a relatively straightforward document, even more straightforward than the healthcare directive is. So we probably don't need to spend a whole lot of time on this, but we want to make sure we catch everything. So starting at the top there, the first line is you put in your own name and address, and then it says I so-and-so, I Jeff, appoint whoever your primary agent is going to be. If you are married, typically that is going to be your spouse. It doesn't have to be, obviously, but typically that's the case. And obviously, if you're not married, you can pick whoever you want to fill in that role. There are places further on in the document as we get down into it where you can also list alternate agents here, but this is where your primary agent is going to be listed. You also want to insert, as it says in the parentheses there, their name and their address as well. All right. And then below that, you see some sentences there in caps. Those sentences are with reference to the powers that are listed there below, A through N. For most people, as you look through these powers that are down below there, most people are going to select line N, that is all of the powers listed above. And the reason is typically this. Whoever you select, typically, if you trust this person, you want to give them as broad of powers as you can so that they can address whatever issue might happen to come up on your behalf, right? And because we don't necessarily know what those issues will be in the future, giving them the broadest powers possible is usually advisable. Now, if you don't feel comfortable with that, you can always limit the powers that you want to afford that person. And you would do that by initialing the powers that you want them to actually have, and then leaving blank or lining out the powers that you don't want them to have. But by and large, most people will be just simply initialing line N there at the bottom. Okay? All right, moving on. You see below there is a section for special instructions. Again, oftentimes in the powers of attorney that we create within our office here, we have specific powers that we also give to agents. In this case, because of the situation that we're in, that's not really all that possible to get really specific about certain powers that you might want to give to your agent. So by and large, you're probably going to leave this section blank. If there are specific things that you have in mind where you might want to say, I don't know, give them additional powers to take care of pets or something like that, because that kind of thing is not, even though it could be maybe identified under personal and family maintenance, it's not absolutely clear about pets. Maybe you want to stick something like that in those lines. Those kinds of things where you don't feel like the powers listed above accurately capture the kinds of powers that you want this agent to have. You may want to list something there in that section as well. Or you may want to restrict something specific in those powers that are listed above in sections A through N. All right. Below those lines there, you see again in caps, there is some language there that says that this power of attorney is effective immediately and will continue until it is revoked. This is a durable power of attorney. That's what that durable portion of the power of attorney stands for. It is effective immediately and continues on, right? And then actually the sentence below that is really what makes this durable. It makes it continues on even if you become incapacitated, right? So that it's effective immediately, it's probably advisable that it stay effective, that it be effective immediately in these circumstances, given the circumstances that you are all in at the moment, and given that this is a stopgap kind of a measure. You probably want these things effective immediately. And then again, the sentence below that says that the power of attorney then continues until, even though if you become incapacitated, this is absolutely the reason that you want this power of attorney in place in case something were to happen to you while you are on the front lines. You want this to continue on so that someone can continue to act on your behalf during that period of time. But it also raises a separate point, which is that once we get beyond all of this, I suppose that there is the possibility that you might actually want to terminate this power of attorney at that point. You may not, but if you did, we don't have these forms included with these documents here, but if you did want to revoke that power of attorney, it's really pretty simple. You just simply write something on a piece of paper that says, I, Jeff, hereby revoke the power of attorney that I signed on whatever date you signed this power of attorney, and hereby revoke all of the powers associated with it. And you probably also want to get that document notarized as well. Because this power of attorney is notarized, you likewise want to get the revocation of that power of attorney notarized as well. So, but it's pretty simple to make that happen. But if you want to revoke it at any point in the future, that's how you would go about doing that. And again, it can be a really straightforward thing. You don't have to type anything. You can handwrite it. If you want to type it, of course, you can do that, but you don't have to do that. You can simply handwrite it. Okay? All right, and then below that there, you see places to list alternate agents. There's a first alternate and then a second alternate. Again, you want to include their name and their address. And then below that, there is a place to also appoint conservators. Just so you know what a conservator is, that is a court-appointed person to handle your financial affairs on your behalf. If for whatever reason this power of attorney is not honored, not accepted, or maybe you only have, for whatever reason, it's not valid, right? This may be a place where your wishes as to who you would want to actually be appointed. The only way that someone else could get authority to act on your behalf at that point would be via a court order. This nomination here would actually give the court some sense of who you would want to act on your behalf and who the court might appoint to act on your behalf. Typically, we would probably recommend that you name the same people that you've named as your agents under these powers of attorney. So you would put your primary agent there in the first blank, and then your alternate there in the second blank. There is not a place for a second alternate nomination there. So you probably just want to put your first two in there. I would not go so far as to start writing things in the margins or the blanks there, or adding a third blank there to fill someone else in. For now, we don't want to risk this power of attorney being rendered invalid because of that. So stay within the bounds of the document itself and just fill in the two blanks for now. Okay. Below that, there's a paragraph that describes a bond requirement in a conservatorship proceeding. A bond is simply an insurance policy, and we'll talk about that more when we talk about the statutory will. But that bond is there to protect your assets, so that if your conservator, for whatever reason, gets into power and runs off with all the money, that bond is there to protect you. You might say, well, of course I would want that in place. But the reality is that if you are picking someone that you trust to be that conservator, they're not likely to run off with those assets. And then in that point, that bond, which costs money, just becomes a waste of money. So most often in powers of attorney, you will see a waiver requirement when discussing a conservatorship appointment. And so that's why it's automatically just in there in this form. All right. Below that, you may decide that you want to pick multiple agents to work with you, co-agents, to serve on your behalf. There are different schools of thought about whether that's a good idea or not. My personal opinion is that I am not a fan of co-agents. I think it leads to conflict and dissent, and in some cases inefficiency. if those agents were to have to act jointly in every regard. This power of attorney allows you, if you look there in the CAP language, to decide whether or not, if you have co-agents, to allow those agents to act independent of each other, or if they must act jointly. And if you are okay with them acting independently, you write the word. They use the word separately. You would write the word separately in that blank. If you require them to work jointly together, then you would obviously write jointly in that blank. There are reasons to have co-agents, and maybe it's a matter of geography. One's located close by, and another one is far away, but they have different skill sets or something to that effect. But maybe there are other reasons out there as well why you might want to have two agents or multiple agents involved acting on your behalf. But again, my preference is generally to go with single agents, but to the extent that you want that, you would want to fill in that blank there. Okay? And then below that, you would go ahead and sign it. You date there, you sign in the blank below that, and then there's a place to print your name, and then there's a place where it says State of California and the county of. You want to sign the county in which you are actually signing this document, not necessarily that you reside in. Okay, and then on the next page, this document, Caitlin talked about that the healthcare directive could also be witnessed. It could be witnessed or notarized. This power of attorney, unfortunately, must be notarized. So, and she mentioned that that there are UPS stores available. Your bank could also be an option for getting a notary, and it's possible that your employer might also have a notary as well. So you may want to check there. That may be the simplest option. That may not obviously be possible, but to the extent it is, you might want to check on that as well. But it does need to be notarized, and hopefully you want to, if you sign it ahead of the document actually being notarized. My guess is that it's not likely to be honored until it actually has a notarization certificate attached to it. But if you are in a pinch and you need to get it signed and you can't get to a notary, you can go ahead and do that. But you should try to get to some notary as quickly as possible. Okay. And with that, I will again turn the time back to Caitlin to discuss assets and how we deal with some of those things if something really tragic were to happen.